video, we will discuss family law for our MEE Highly Tested Topics Guide. First, let's talk about the frequency in which family law has been tested on the exam. Family law is tested about once a year. Thus, it is a frequently tested topic and should be on your radar. Family law is also usually tested alone, but it has been tested with conflict of laws before. Please check out that portion of our guide to see how the examiners have crossed over the subjects. Next, let's talk about the highly tested family law issues. Before we dive into the specifics, we want to point something out. We have found that traditional bar prep courses spend a lot of time on things that are not frequently tested. For example, things like the general requirements of marriage or defenses to fault-based divorce or gestational agreements. While this information may be helpful for you to gain background information, they are simply not highly tested issues. So hopefully we can better direct your attention to those things that are highly tested. The first set of highly tested topics relate to children, and more specifically, child custody and child support. So when it comes to these topics, first note that child custody is determined by the best interests of the child factors. You should memorize that phrase, best interest of the child, because those are buzzwords that you want to be able to write down on an essay that tests this issue. While there are a number of factors that vary by jurisdiction, we would not suggest that you try to memorize all of them. Instead, you should be familiar with them and, in response to a question, list those that are relevant and analyze them to reach a conclusion. Turning to child support, all states employ a numerical guideline that establishes a rebuttable presumption that the award that results from applying those guidelines is correct. The guidelines must be applied in all cases, regardless of the parent's marital status. The court looks at factors such as income of the parents, the number of children, and the ages, as well as any special needs that the children may have. Now, this is rebuttable, so a party could come forward with evidence to illustrate how the award is not proper, but the burden would be on that moving party. When it comes to the modification of a custody order or child support order, you should know that these are modifiable if there has been a substantial change in circumstances. I previously mentioned that knowing buzzwords is helpful and will make your essay stand out. Well, that phrase, substantial change of circumstances, is one you want to know as well. However, when a party seeks to have child support modified because they have voluntarily reduced their income, courts take different approaches to this issue. Some courts refuse to modify the order. Other courts take a multifactorial approach, which includes examining whether or not that party reduced their income in good faith. For example, if a mom took a lesser paying job to be able to live closer to her kids and thus have more time to spend with them, in jurisdictions that consider whether the change was done in good faith, they'd consider this information in the mom's favor. Additionally, when parties have a child, their rights are not necessarily determined by virtue of their marital status. Instead, biological fathers have rights to their children, even if they weren't married to the mother at the time in which that baby was born. However, some states do have laws that require biological fathers to take action within a certain window of time to have those rights, and those laws have been deemed to be constitutional. Turning to our next highly tested topic, property division and alimony. So we're shifting gears just a little bit. Instead of talking about children and child support, let's talk about the parties ending their marriage and what we do with their property, and of course, issues of spousal support. First things first, be familiar with what is marital property versus separate property. Being able to identify and define these assets is important because the majority of jurisdictions state that marital property is subject to division, whereas separate property stays separate. So you want to be able to define these terms on an essay. Marital property is defined as property acquired by the parties throughout the marriage, whereas separate property includes property that was acquired before the marriage, like an inheritance that one of the parties to the marriage has received, or a gift given to just one of the spouses. Be familiar with premarital agreements. If you see a premarital agreement, you should treat it like a contract. This is an excellent backup approach if you forget the specific rules and you don't know what to write in response to an essay that is testing this topic. A court will enforce a premarital agreement so long as it's voluntarily made, substantively fair, and if full disclosure of assets and obligations was made. Premarital agreements will not be enforced regarding things like child support or custody if they're not in the best interests of the child. From a public policy perspective, we like premarital agreements because they foster settlement over litigation. Turning to alimony, these awards can be permanent or temporary, or they can be granted in a lump sum. States consider different factors when making these decisions regarding whether or not to award alimony, including the parties' financial resources and their needs, marital contributions, as well as marital duration. Orders for alimony are generally modifiable upon a showing of a substantial change in circumstances. You'll notice that is the same set of buzzwords that we use for the modification of a child support order or a custody order. So again, you want to be familiar with this language. Next, let's discuss the Uniform Interstate Family Support Act, or the UIFSA, as well as the Uniform Child Custody Jurisdiction and Enforcement Act, or the UCCJEA. Turning first to the UIFSA, this governs child support. Under the law, once a child support order has been registered, it can be enforced by any state. This is nice because it makes enforceability so much more clear-cut and straightforward. The state that originally issued that child support order will retain exclusive jurisdiction to modify it, so long as that state remains the residence of the obligee, the child, or the obligor, and at least one of the parties hasn't consented to use of another forum. Next, turning to the UCCJEA, or that Uniform Child Custody Jurisdiction Enforcement Act. This governs custody orders. This statute incorporates various tests, starting with the home state test, and this is usually the one that's tested on the essays. The home state of a child has exclusive jurisdiction to modify a custody order. And we define home state as where a child has lived with a parent or someone who's acting like a parent for at least 6 consecutive months immediately prior to the commencement of this proceeding. A home state will continue to have exclusive jurisdiction to issue a custody order for 6 months after a child has left the state, so long as a parent or someone acting as a parent still lives in that state. So you'll note that a home state remains the home state even after a child leaves that state for 6 months, so long as a parent or someone acting like a parent remains in that state. So in other words, a home state is not necessarily where the child is physically located. If a child does not have a home state, you want to move on to the significant connections test. Our third tip is to be aware of how certain family law topics are tested. This way, if you're ever unsure of what the outcome should be or what to expect, if you can remember this information, you're likely to feel more confident and get it right. So to give you one example, when it comes to retroactive modification of child support, federal law forbids this, absent circumstances of fraud. So if you can remember this rule, you'll likely answer the question correctly. The outcome has always been the same on the MEE. The best way to become familiar with how they test issues is to practice past MEE questions. So that leads me to my final point, practice. Be sure to carve out time to practice a variety of different kinds of family law MEEs. Practice will expose you to those different kinds of issues that the examiners test and how those issues tend to be tested. So that wraps up our discussion of family law.